Okay, welcome to the Raines Feldman Cyber Liability Update. I am Eric Cyberson, and with me, of course, is Scott Lesowitz. And for numerous reasons, we haven't done one of these in a while, but we're getting back in the swing of things, Scott. And Scott, you and I are working a lot of, or I should say, defending a lot of FTC marketing cases, and they involve internet marketing. So, I wanted to talk about what differences there are, to the extent there are any differences, in defending an FTC case, which is a civil case, and perhaps a criminal case brought by another type of agency. So let's say you're an internet marketer and the FTC comes knocking on your door and they accuse you of engaging in deceptive internet marketing practices. What's the difference in defending that as opposed to defending a criminal case? And we should say you used to be an AUSA, so you know something about the criminal standards of proof.
So one of the differences, if for actual people who are committing the wrong, people who are stealing people's information, stealing credit card information, whatever the case is about, there the criminal law and the FTC law overlap. If you are the person directing the wrongdoing and it violates criminal and FTC rules, which often is the case, you're subject to both criminal charges and FTC lawsuit. But where it gets more murky and different is where you have supervisors, whether it's corporate officers or just managers, who know about wrongdoing, know it's occurring, but don't take steps to stop it, but at the same time are not actively participating in it. And the general criminal law rule in the United States is that if someone knows about a crime, he doesn't have a duty to report it, and as long as he or she is not participating and actively furthering the crime, he or she's not criminally liable. Whereas with FTC cases, if you're a supervisor or corporate officer and you have the authority and ability to stop the program, or even if you have the ability just to control it or manipulate it, and you know about it, that's enough. You have an affirmative duty in that situation to actually take steps to stop it, to leave the company, report it to the FTC, but you can't just sit back and not do anything.
I see. So, the net is, it sounds like much wider with the FTC. Now let's talk about the differences and the downside. So let's say you're a middle management type in the scenario we've explained, internet marketing company, and there's some funny business going on. Things aren't kosher. Now, what could the FTC, what can you expect the FTC to want from you?
They're going to want to see, in my experience, oftentimes the FTC expects people to be a bit superhuman, and that is that if you are just continue to work at the company, even if you don't like what's going on, even if you make some attempts to move the company away from it, that's insufficient. You either need to be very safe, you need to report it to the FTC, leave the company, or have a good written trail that you were saying, we need to stop doing this, stop this, or else I'm going to leave. I want no part of this. This should stop. I'm going to do everything in my power to stop it. You can be liable.
It's a tough standard because, look, obviously there's a human element to it. Jobs aren't necessarily easy to come by, and if you've got a family to support, you might have to hang in at a company like that. You can't just leave right away. Is there anything that we can think of that, you're supporting the family, you have to pay the mortgage, you can't necessarily leave? It sounds like the best option would be to paper your objections. Would that be fair to say, whether it's emails to your superiors or the CEO?
Yeah, I would say paper it and exercise whatever control you have to stop the wrongdoing. Obviously, if you're a middle manager, it might first of all be a question of whether you have enough authority over what's going on. But if you have what's seeming like a reasonably substantial amount of authority, use it to try to do something right. And you know, it's hard. It's hard when you're supporting a family to be that person. But I mean, you can take solace in laws that prevent firing, you know, in retaliatory firing in these situations, and avoid the FTC, and at the same time you accrue a cause of action for employment-related torts, which you oftentimes get attorney's fees for. But it's a tough situation. It's really hard, and I think that people who are in this situation, it's very fact specific, and are better off hiring an attorney and consulting with an attorney, because it's very nuanced and very difficult, and it's a very fine line. But what you don't want to have happen is that you do something because you want to support your family, but then the FTC comes and you get completely wiped out, which often is the case.
Well, I think that's the mistake most people make, frankly. I mean, you know, look, it's expensive to hire experienced counsel, but oftentimes it is very cost effective in these situations. The reason why I say that, and you just alluded to it, is once the FTC gets their teeth into you, it can oftentimes be paralyzing, because they will freeze your assets, and you will have a much harder time retaining counsel and defending the case. So it's much better to spend that money early on and consult a lawyer if you're in this hypothetical scenario we're talking about. Of course, consultations with your private attorney are privileged, so the FTC is not going to find out about it, and your employer won't find out about it. So that's, I think, some good practical advice for anybody out there in that situation that might be facing an FTC action. That's all for the Cyber Liability Update this week, and hopefully we'll see you soon.